Do you swear or affirm under penalty of perjury that the testimony you're about to give will be the truth and nothing but the truth?
I do.
Please. If you would. Thank you. And if you could begin, let's make sure the microphone is pointed towards you a little bit. There we go. If you could begin by giving us your full name, spelling each of your names.
Barry Vance Broad, B-A-R-R-Y, V-A-N-C-E, B-R-O-D-D.
Mr. Nelson.
Thank you very much. Good afternoon, Mr. Broad.
Afternoon.
Are you currently employed?
I am.
And where are you so employed?
I'm self-employed as I own a consulting company, BVB and Associates.
And what areas do you consult in?
Police practices and use of force.
All right. Now, did you have a career as a police officer prior to starting your company?
I did.
Can you, for the jury, please describe generally your education that you received in order to become a police officer?
So I have a bachelor's degree in law enforcement from George Mason University, which is in Fairfax, Virginia. I have a California Community College teaching credential from San Francisco State University, and I'm a graduate of the Labor Management Relations Program at University of California at Davis.
Okay. And did you serve as a licensed police officer in various capacities?
I did.
When did you start your law enforcement career?
So when I graduated college, I was a seasonal police officer in Ocean City, Maryland. Then I was a deputy sheriff for 6 months with the Arlington County Sheriff's Office in Arlington, Virginia, assigned to the custody division. Then I was hired by the United States Park Police, which is a law enforcement branch of the Department of Interior.
Is that a federal law enforcement agency?
That is a federal law enforcement agency. Okay. And I started my career with the Park Police in Washington, D.C., and then I was transferred to San Francisco field office in 1977. Then I went on loan to an undercover drug task force in Marin County, California, and then I went to Santa Rosa Police Department in 1982.
And how long were you with the Santa Rosa Police Department then?
22 years. I had 29 years total law enforcement experience.
All right. In your capacity as a police officer, do you have any specialized training or experience?
I did.
And what is that?
So I had special assignments as with the Park Police. I was certified by the FBI as a defensive tactics instructor in 1978. I started teaching in the Santa Rosa Public Safety Training Center, and I also taught law enforcement rangers throughout the western region of the National Park Service.
Can you explain what defensive tactics is generally?
So when you look at the topic of use of force, that could include handcuffing, hands-on techniques, baton techniques, handcuffing, pain compliance, and under the use of force umbrella, there's also firearms, but I focused almost entirely on the defensive tactics portion of use of force.
And so you testified that you taught defensive tactics at, you called it the, I believe, the Regional Training Center?
It is a regional academy, but the official name is the Santa Rosa Public Safety Training Center.
Can you describe what that is?
So recruit police officer would attend the training center for their California Post Basic Academy certification. National Park Service Rangers also attended that academy. Corrections officers attend that academy. Probation officers. And there's also a EMS component. Firefighters go to that academy, and it also services in-service training.
In-service is training for licensed officers?
Yes.
To meet their continuing education credits?
Yes.
And how long did you teach there?
35 years.
In the use of force always?
Yes, in addition to other topics.
What were the other topics that you trained?
Weapons laws, interview and interrogation techniques, collision scene preservation, verbal judo, tactical communication skills, or some of the others.
What's verbal judo?
So it is actually Dr. George Thompson developed the program shortly after the Rodney King incident, thinking that police officers needed better tools to communicate with people. So verbal judo created an outline on how an officer who would make a traffic stop could use verbal skills to overcome a person's potential noncompliance.
Did you also teach or in crowd control, crowd management type issues?
I did. So of the topics I taught at the training center was defensive tactics, crowd control, chemical agent, impact weapons, and a variety of the other topics that I just discussed earlier.
Okay. And so you did that for 35 years while you were still actively a peace officer?
So I taught while I was a police officer, and then when I retired in 2004, I continued teaching in the training center for another 9 years.
All right. Do you have have you received any certifications throughout the course of your career?
Several.
Can you describe for the jury some of the certifications that you've held?
So I have a post-basic, intermediate, and advanced certificates. And then as far as instructor certifications, I was certified by the FBI as a defensive tactics instructor. I was certified by the California Peace Officer Standards and Training Commission as a defensive tactics instructor. And through California Post, I was also an impact weapon instructor, chemical agent instructor, less lethal munition instructor, verbal judo instructor, pepper spray instructor, to name, I can't remember them all.
Okay. Can you describe the nature of your private practice, so to speak, in terms of the use of force?
I take cases from plaintiffs and defendants in civil cases and criminal cases. I do use of force consulting for a variety of public defenders' offices in California, and I was also a member of I was a use of force consultant for the San Francisco District Attorney's Office.
Okay. Have you been involved in prior cases to review the uses of force?
I've had a little bit over 140 cases that I was actively involved in.
Okay. Have you provided testimony in courts throughout the United States?
I have.
Or other arbitrative type civil hearings?
Yes.
Can you tell me the number of times that you've testified in either civil or criminal cases?
So since 2016, I've testified in court, either criminal or civil, both state and federal, 10 times.
And in terms of other types of hearings, depositions, things of that nature, do you testify there as well?
Yes.
Can you describe some of the states where you have previously testified?
Illinois, California, Hawaii, and that's about it.
Have you ever been hired on a case here in Minnesota?
Yes.
And who hired you in that particular case?
Minneapolis City Attorney's Office.
Now, you're being paid for your services, correct?
Yes.
Can you tell the jury your hourly rate and the number of hours you've spent on this case?
I've spent roughly 60 hours. I make $350 an hour for courtroom appearances and $275 an hour for case reviews.
And how much have you, what's the total about you've earned so far?
In this case, $11,400.
Now, simply because you're being paid, does that mean you're going to always, by a particular party, does that mean you're always going to side with that party?
No.
In your career, have you ever been retained by someone and found their use of force to be improper?
Several times.
How is it that you became involved in this particular case?
When this incident first occurred, I reached out to the city attorney's office here in Minneapolis, told them that I had some exposure to the George Floyd incident, and I was offering my services to the Minneapolis City Attorney's Office.
And you were ultimately not retained by the city attorney's office or the state, correct?
That's correct.
You then were retained by my office?
Yes.
Okay. When you were retained, were you provided with a scope of your engagement?
I was.
Could you explain for the jury the scope of your engagement in this particular
You
case?
asked me to analyze the actions of Derek Chauvin and give opinions regarding his conduct and actions towards Mr. Floyd.
Can you describe the materials that you reviewed in order to analyze this case?
So I received thousands of pages of materials, but I've learned through my experience that I don't need to review materials that really don't have anything to do with the officer or the officer's policies or the use of force policies. So I've pretty much focused my review on the videos, the snapshots of the body-worn cameras that the officers were wearing, miscellaneous statements, the use of force policies, and training records.
So when you say there were some materials that were not relevant to your analysis, can you just kind of give a general example of what that would be?
Horse-mounted patrol responsibilities, vehicle maintenance responsibilities, things of that nature.
Okay. But anything pertaining directly to your analysis in this case, you did review?
I did review.
Now, based upon your training and experience and your expertise in the use of force matters, your review of the materials that have been provided to you, have you formed opinions in this particular case to a reasonable degree of professional certainty?
I have.
And can you just briefly overview your opinions in this particular case?
I felt that Derek Chauvin was justified and was acting with objective reasonableness, following Minneapolis Police Department policy and current standards of law enforcement in his interactions with Mr. Floyd.
Okay. We've heard a lot over the last couple of weeks about the Graham versus Connor factors. Are you familiar with the Graham versus Connor factors?
I am.
And can you just very briefly provide your definition and your how you look at those factors?
So in my 35 years of teaching, it's not just dealing with tactics, but it's dealing with providing an officer the mindset that what they need to justify to use various tactics that they were trained in. And the standard of Graham versus Connor is, what would a reasonable officer have done in a similar set of circumstances that you're doing?
Now, the Graham versus Connor factors, the first one is the severity of the crime at issue, correct?
Yes.
How do you analyze that Graham versus Connor factor?
So I know in my experience and the experience of officers that I've been in contact with is that the higher risk an arrest may be, like say an armed bank robber. Armed bank robber, you would pull your gun, order them to the ground to take them into custody. Okay, you know their danger, you know their threat level right off the bat. Whereas I can't imagine how many times I've been exposed to personally or have seen other officers dealing with a simple thing as a traffic stop or a jaywalking violation or some minor offense, and they end up in a fight for their life just because of the conduct of the individual they're contacting.
Okay. So in terms of the severity of issue, is it always what was the initial response in your or is it something that evolves over time?
Well, the initial response, of course, is important, but it's really how the person you're interacting with as a law enforcement officer responds to you.
Okay. And does that go into the second Graham factor?
It does, the imminent threat.
Right. And can you just explain the imminent threat factor?
So imminent is, from a police officer standpoint, you don't have to wait for it to happen. You just have to have a reasonable fear that somebody's either going to strike you, stab you, shoot you. So you try to plan to deal with the imminent threat, and then you adjust your tactics accordingly based upon how the suspect is reacting to you.
Okay. And the third Graham factor is whether the suspect is actively resisting or attempting to evade, correct?
That's correct.
And can you explain that to the jury?
So again, the level of resistance is commensurate with how they resist you justifies an officer to use a variety of tools on their tool belt. So if a suspect is resisting your efforts to handcuff them and they spin away and try to punch you, An officer doesn't have to go fist on fist with them. The officer's allowed to escalate to use an impact weapon, taser, pepper spray, or other tools.
Now, in terms of, again, the analysis of Graham versus Connor, are there other factors or components of that analysis that are relevant?
Yes.
Can you explain some of those?
So as you're reviewing an incident such as this, you have to try to see it through the eyes of the officers on the scene. You know, what factors were they dealing with? What circumstances? What was the suspect doing? What were onlookers doing? Were there environmental hazards? And then try to put yourself in the officer's shoes to see what the decisions they made, were they objectively reasonable or not.
So you would agree with the other people who've testified in this case that the standard involves objective reasonableness? Agreed?
Yes, I do.
Based on the totality of facts and circumstances of this case?
That were present to the officer at the time.
And a view from a reasonable police officer on the scene?
Yes.
And what about hindsight?
So it's easy to sit and judge in an office on an officer's conduct. It's more of a challenge to, again, put yourself in the officer's shoes to try to make an evaluation through what they're feeling, what they're sensing, the fear they have, and then make a determination.
And does that prohibit or preclude a review of a police officer's conduct?
No, not a review, no.
Now, when you approach a use of force case such as this, do you apply a particular methodology in order to analyze the Graham versus Connor factors?
I do.
And can you explain for the jury the methodology that you've used in your previous cases or in your career?
So it's a pretty simple review. So I look at when the officer contacted the individual, did the officer have legal authority for a detention? So let's talk about a traffic stop. If somebody runs a stop sign, police officer has the right to detain you, do a citation. You, as the person running the stop sign, doesn't have the right to resist the officer. So anything that would have evolved from a lawful detention, the officer has certain rights to continue the investigation. Now, a detention you need reasonable suspicion for. To make an arrest, you need probable cause. So when I'm looking at use of force cases, I want to make sure that the officer had a lawful right to detain or probable cause to arrest.
And in terms of the lawful right to detain, you used a term. What was that term? Reasonable suspicion?
Reasonable suspicion to detain.
And what constitutes generally reasonable suspicion to detain?
That you see an infraction or a misdemeanor or a felony, and the person that you're going to detain, you have a reasonable suspicion that they've committed an infraction or another crime.
And in terms of probable cause to arrest, how would you define that?
It's pretty much as the statement says, that the person probably committed the crime. And so officers, when they make an arrest, they base it on probable cause.
So in terms of putting a suspect in handcuffs, is that automatically an arrest?
No.
Can it be a detention?
Could be a detention.
So the first, just to make sure I understand your testimony, your first prong of your analysis is to determine whether the officer had justification to detain the suspect, correct?
Yes.
What's the second part of your analysis?
Now, how does the suspect respond to the officer? If it's an arrest situation and the officer tells the suspect to turn around, put your hands behind your back or behind your head, and the suspect complies, and the officer handcuffs the suspect, that's good. If the suspect doesn't comply and they begin to resist, then I look at what level of the resistance did the suspect display to the officer, and then what did the officer do to overcome that resistance.
Now, let's talk briefly in the second prong about the different types of resistance that a suspect could use. Can you describe the levels of resistance that you look for?
So no resistance would be compliance. That's always the goal. The next level would be passive resistance, where a suspect You tell the suspect to turn around, put their hands behind their back, and they don't. They're not resisting you. They're just being physically non-compliant, yet without any type of physical strength or any type of maneuvers that they may try to do to prevent you from handcuffing them. So the next level would be active resistance. So I go to put you into a handcuffing position, and you pull your hands away, or you struggle with me. So that's active resistance, where they're using energy to prevent an officer from accomplishing their goal. And then now that same suspect who I want to handcuff pulls away from me, and they swing at me. So that's active aggression. And all those cues are allowing me to start escalating up the ladder of force options I have available to me.
Now, in terms of your experience in various jurisdictions, do use of force policies differ from city to city, state to state?
They differ slightly. Usually deadly force policies are fairly consistent. Some agencies have more liberal use of force policies than others. Some agencies now are starting to adopt policies that you can't shoot at a moving vehicle if the only weapon is the vehicle itself. So there's a little bit of a learning curve there for agencies.
Okay. So in terms of your, again, analysis, the first prong being whether there was a justification for the detention, the second prong being the level of resistance exhibited by the suspect, correct?
Yes.
What's the third prong?
What the officer did to overcome that resistance. So if somebody pulls away from you and they're actively resisting, does the officer pull out their baton and strike them in the head? That to me would be excessive.
Okay.
So was the officer's use of force proportionate to the level of resistance demonstrated by the suspect?
Objectively reasonable, correct?
Yes.
All right. So in terms of your three-part analysis, did you apply that analysis to this case?
I did.
In your opinion, was this a use of deadly force?
It was not.
Can you explain that?
So I'll give you an example that I used to teach my academy classes. So officers respond to a domestic violence situation, and the suspect is still there, and he fights with he fights with the officers, and the officers are justified in using a taser to overcome this person's noncompliance. They tase the individual, and the individual falls to the ground, strikes their head, and dies. So that isn't an incident of deadly force. That's an incident of an accidental death. And in my review, I would look to see whether the suspect's resistance to justify the use of the taser was objectively reasonable.
Can you describe what you would call control techniques?
So control techniques are me putting my hands on you. And it could be, escort position where I put my hand above your elbow and my hand on your wrist. It could be pain compliance techniques, which means I'm doing some joint manipulation on various parts of your body. And if you're doing what I'm asking you to do, it doesn't hurt. If you don't do what I'm asking you to do, I can motivate your compliance through pain compliance, stimulating you with pain.
Now, in terms of your analysis of any case, I think you described this a little bit, but did you refer to kind of an increase of level of force to overcome the resistance? How would you describe that?
Police terminology is called one-upmanship. So, police officers don't have to fight fair. They're allowed to overcome your resistance by going up a level or resorting to a different force option to let them accomplish the goal of getting you to comply.
Are officers also required to de-escalate in certain circumstances?
Yes.
And can you describe the process of moving up or down that use of force?
And it's always in response to what a suspect is doing. So if they're fighting, you're fighting back. You're trying to control them. Once they're controlled, you reduce your justified levels of force, yet you're still in control of the person. Anybody you take into custody, you have to maintain control of.
Again, in terms of the use of force, what relevance does possible drug influence have in an analysis?
Has quite a large impact, in my opinion.
How so?
Well, because people under the influence of drugs may not be hearing what you're trying to ask them to do. They may not understand. They may have erratic behavior. They may have they don't feel pain. So techniques you would normally use to make somebody comply, they're not feeling. They may have superhuman strength, or they may have an ability to go from compliant to extreme noncompliance in a heartbeat.
Do you train officers to keep drug-influenced suspects handcuffed?
I do.
Why?
So there's been many instances where handcuffs were removed from a drug-influenced suspect, and as soon as they were removed or some type of first aid measure started to be applied, the person is right back to fighting you, and you're in a fight for your life. So I've trained, and I've been trained, that when you're dealing with drug-influenced persons, they stay handcuffed until they're taken to a medical facility, if that's what the case may be, and they're put in soft restraints on a gurney so they can be treated.
Can you describe the concept of situational awareness?
Yes, I kind of break it down that a police, most people's head should be on a swivel. If you're walking down a street and you hear somebody running up behind you, your mind thought shouldn't be, well, I wonder if they're going to tackle me, if they're going to rob me. No, you head on a swivel, which means you're cognizant of your awareness, see things that may be a threat or hazard to you, plan for them. And especially as a police officer in uniform stands for certain things. Unfortunately, criminals don't wear uniforms, so officers don't have the luxury of being able to look at somebody and automatically determining if they're going to be a threat or a risk to them or not.
Does the concepts of situational awareness come into or factor into your analysis?
It does.
How so?
So what other threats are present besides the person that we're dealing with? Are there environmental hazards? Is there traffic going by on the street? Are there onlookers? Are there more people starting to focus on your arrest versus just walking down the sidewalk? The officer's exhaustion level. What are other officers doing? Things of that nature.
Is an officer entitled to rely on information he or she receives from dispatch in formulating whether they're going to use force?
In justifying force, I would say no. In preparing to deal with the situation they're being sent to by dispatch, then I would say yes.
Okay. How does that differ?
So an officer has to take into account what they see on the scene. Dispatchers do the best jobs they can, but they're usually only getting information over the telephone. And the information may be inaccurate, may be false, may be exaggerated. So it's up to the officer on the street to determine what is the best course of action.
Have you reviewed Officer Chauvin's uses of force in this particular case, taking into consideration your analysis as well as some of the concepts we've talked about?
I have.
And let's talk about Mr. Chauvin's uses of force. Where would you say the first use of force that Mr. Chauvin engaged in occurred?
When he joined Officer King in Lane trying to put Mr. Floyd in the backseat of the patrol car.
And in your view of that use of force, what is your perspective on that?
That Mr. Floyd's level of resistance was objectively reasonable for those officers to do the techniques that they were doing. I felt that level of resistance exhibited by Mr. Floyd justified the officers in higher levels use of force that they chose not to select.
And would that be if an officer chooses not to use a higher level of force, is that an element of de-escalation?
Objection leading? Rephrase.
how does an officer's decision to use less force factor into an analysis of de-escalation techniques?
So, an officer sees an incident, feels it has these justification to use these tools to deal with the incident, but just due to the personality or the personal makeup of the officer, they chose not to. They try to expire a lesser technique to see if it'll work. And then if it doesn't work, then they escalate.
Okay. Now, you testified you've watched the videos in this case?
Yes,
Does that include the body-worn cameras of the Minneapolis police officers involved?
it did.
Did it include various bystander videos
Yes,
and surveillance videos from area stores?
yes.
And from your perspective, just generally, what are some of the limitations of camera analysis?
So a body camera shows what the camera is pointing at. It doesn't see what an officer may see in their peripheral vision, doesn't show what an officer is actually feeling through their hands or sensing through their levels of awareness. And in low light situations, a body cam shutter responds to lighting situations quicker than the human eye does.
Overruled.
Your last statement?
About the shutter release on the body cam is that it adjusts quicker to lighting situations than the human eye does.
Now, so in terms of the initial uses of force, the officers' efforts to get Mr. Floyd into the car, you felt that they were objectively reasonable.
I did.
Did the use of force then continue after Mr. Floyd was restrained on the ground?
I don't consider a prone control as a use of force.
Let's back up just a second. The removal or Mr. Floyd's getting out of the vehicle, however that was, does that constitute a use of force?
The manhandling or the three officers taking Mr. Floyd out of the car and placing him on the ground, yes, that's a use of force.
Was it justified or objectively reasonable in this particular case, according to your opinion?
Yes.
So when they brought Mr. Floyd to the ground, are you saying you don't consider that to be a use of force?
Up to that point, it was still a use of force, yes.
Once Mr. Floyd is on the ground, in your opinion, does there continue to be some level of resistance by Mr. Floyd?
Yes.
How would you describe that?
Active resistance. He was still struggling against the efforts of the officers. And I saw on one of the body cam videos that Mr. Floyd appeared to kick at Officer Lane.
Is there a reason why officers would take a suspect, actively resisting suspect to the ground?
Yes.
Why?
So officers are trained that anytime you get resistance from a suspect or you're dealing with a high-risk suspect, it's safer for you, the officer, and for the suspect to put him on the ground in a prone position face down for a variety of reasons, some of which are it makes the suspect's mobility diminished. They can't get up and run as quick. It takes away some of the use of their hands, so they can't grab you without turning their body, which would give an officer time to react. It limits what they can do with their feet. They can still kick, but they don't have as much mobility or power that they would if they were standing. Now,
in terms of this particular case, you understand Mr. Floyd was handcuffed at this point.
Yes.
Does the fact that Mr. Floyd was handcuffed somehow come into the analysis as to whether or not to put him into a prone position?
No, any resistor, handcuffed or not, should go to the ground into a prone control position.
And can you describe generally what you mean as a prone control position?
So it's where the suspect either, in this case, handcuffs are behind the back, placed on their stomach and their chest, and officers are in a position to apply body weight to keep the suspect on the ground and to keep them further immobilized.
Would it be common practice in that situation to employ an MRT or hobble restraint?
You could.
What would be the factors to determine whether or not an officer would employ such a technique?
So can the officers control the person's legs? Does the person need to have their legs controlled in the situation they did? And could Officer Lane be successful in trying to control the legs? So it was those part of the force option selections that they had to make.
In terms of your familiar officers in this particular case, considered the use of the MRT?
They did.
And they ultimately decided against it, correct?
That's correct.
How does that factor into, or the decision to not employ the MRT factor into the analysis?
That it's one of those situations where they were justified in the maximum restraint and chose not to. So why they had that decision making, I'm not sure. Maybe, Mr. Floyd had made comments about being claustrophobic. And I know in the teaching I've done with leg restraints, if you leg restrain somebody in training or on the street that is claustrophobic, it creates a reaction.
How does the fact that EMS had been summoned factor into your analysis?
That I think what I've read in the materials is that there was a fire station literally seconds, if not a minute to a minute and a half away. So if you have somebody that's under control and is in need of medical attention, and EMS, who have the training and equipment to do a lot better job than police officers can do, that would be relevant to me that, okay, we call them, they're going to be here instantaneously. Let's just kind of stabilize the situation and wait for the professionals to show up.
Would a reasonable police officer, based on the reasonable police officer standard, is that a factor that comes into the analysis, the EMS response time?
Yes.
What about a suspect, keeping a suspect in the prone position who is potentially drug impaired? Are there safety reasons to do that?
Again, so as I discussed earlier, potential erratic behavior, going from compliant to non-compliant, not feeling any pain, potentially having superhuman strength, and it's just safer for the officer and for the suspect to keep them in that prone control.
Why would it be safer for the suspect to keep him in that prone control?
Because if they were to get up and run, handcuffed, trip and fall, sustain facial injuries, other injuries on the ground, their mobility is reduced, their ability to move is reduced, and the ability to hurt themselves is reduced.
What if they became sick, for example?
Prone control, instead of having somebody lay on their back where they could aspirate on vomit, prone control, their face is down, airway is clear. If they vomit, it's not going to go down their trachea or down their throat.
Now, you've obviously, in addition to watching the cameras, you heard what Mr. Floyd was saying at that time, right?
Yes.
And how do officers take into account an analysis of words versus conduct?
So you hear what the suspect is saying. So if I want Mr. Floyd to get in the back of the car, and he's saying, I will, but he's not, and I'm trying to force him in, he says, I will, but he's not, then his actions are telling me he's not getting in the car regardless of what he's saying.
What about as Mr. Floyd was going into the car and there was this act of aggression, as you've defined it, and Mr. Floyd at that point was saying he couldn't breathe, but he continued to say that later. How did the words he was saying initially comply or comport with his actions in that instant?
I have advanced first aid. I certainly don't have medical degrees, but I was always trained and feel it's a reasonable assumption that if somebody's, I'm choking, well, you're not choking because you can breathe. If somebody's saying they can't breathe, it appears to me
assumption
that
if
full breaths and shouting, to me, the layperson, they can breathe.
Is that a common misunderstanding within the policing community?
I believe it is, yes.
Objection, lack of foundation.
Overruled.
So in terms of a reasonable police officer standard again, is a reasonable police officer who has used force in an instant, can they consider that in prolonging a detention or a prone control of a suspect?
So if the officer was justified in using the prone control, and now the suspect is on the ground in a prone control, the maintaining of the prone control to me is not a use of force.
Why is it not a use of force?
Because it's a control technique. Without it doesn't hurt. You've put the suspect in a position where it's safe for you, the officer, safe for them, the suspect, and you're using minimal effort to keep them on the ground.
Now, you're familiar with the concept of positional asphyxia, correct?
I am.
Can you describe for the jury what you train and have been trained that are the dangers of positional asphyxia?
So the training I received is that a target person for positional asphyxia would be somebody who's very obese. And now you take that obese person and you handcuff them behind their back, really pulling their shoulders back, really constricting their rib cage. And if you put them face down on the ground, that would be the training model for somebody who could be prone to positional asphyxia. And when I was first in law enforcement, and the training I initially did regarding leg restraints, is that you used to hobble a person's ankles, tie the ankles to the handcuffs, and then put the person face down, and that created even more pressure on the person's sternum and rib cage and reduced their ability to breathe. So that technique was modified to address the positional asphyxia issues.
You would agree that the Minneapolis Police Department trains officers to place people in a recovery position, correct?
Yes.
And you would agree that that is based out of concerns of positional asphyxia, agreed?
Yes.
Now, are there situations where a reasonable police officer would not put a person in the prone position into the recovery position?
Yes.
Can you describe what those may be?
So in this situation, there was space limitations. Mr. Floyd was butted up against the tire of the patrol car. There was traffic still driving down the street. There were crowd issues that took the attention of the officers. Mr. Floyd was still somewhat resisting, so I think those were relatively valid reasons to keep him in the prone.
Now, in terms of your training, again, as that you have been trained and trained other officers in the use of crowd control or crowd control issues, right?
Yes.
How in law enforcement is a crowd defined?
So a crowd, just like if you look at a football stadium. So it's a group of people gathered together for a common purpose. So a crowd, by definition, isn't unlawful. And actually, the law enforcement definition is two or more people constitute a crowd. So because it's not unlawful, it doesn't mean that it doesn't become a consideration for the officers.
Okay. Can you explain in your analysis how you think the crowd or this group of people that had gathered around and were watching affected the officers in their use of force?
So we kind of go back to the situational awareness issue, is that, yes, the officers are dealing with Mr. Floyd, but there's also other factors for them to consider. And in this case, the crowd started to grow in size, started to become more vocal. So now officers are always trained to deal with, right, so what threat is the biggest threat? Is it the suspect on the ground in front of me in handcuffs that we have relatively controlled? Or is it the unknown threat posed by the crowd that could go from verbal to trying to interfere with my arrest process in a matter of seconds?
Did you factor that into your analysis of this case?
I did.
How did it? How so?
I could see that Officer Chauvin's focus started to move from Mr. Floyd to the crowd. To one point, I think Officer Chauvin felt threatened enough that he withdrew his pepper spray canister and gave verbal commands to the crowd to stay back. So now he's dealing with the bigger threat.
So just to kind of wrap up, could you summarize the final opinions that you have made in this case?
I felt that Officer Chauvin's interactions with Mr. Floyd were following his training, following current practices in policing, and were objectively reasonable.
Thank you. I have no further questions.
Mr. Swisher. Sure. We're going to take a quick bathroom break. 5 minutes, please. And you can step down if you wish. right, sir, you're still under oath. Yes, sir. Mr. Slusher.
Thank you, Your Honor. Good afternoon, sir.
Yeah.
So I'm understanding your testimony, you indicate as a fundamental proposition that the defendant's conduct of restraining Mr. Floyd in the prone position on the ground, handcuffed, was not a use of force.
That's correct.
And I believe, according to your testimony, it's because, in your opinion, that position is not likely to inflict pain. Is that correct?
That is correct.
Now, if it did, in fact, inflict pain upon Mr. Floyd, would that change your opinion?
Only if the positioning of the body or if the officers were manipulating Mr. Floyd's hands in a way that would create pain, then yes, I would say that would be a use of force.
So my question is, if Mr. Floyd actually experienced pain, would that change your opinion? Would it be then a use of force if pain was actually inflicted upon Mr. Floyd?
If the pain was inflicted through the prone control, then yes, I would say that was a use of force.
And the prone control, as we're describing here, just so that we make sure that we're talking about the same terms, would be placing Mr. Floyd on his stomach, correct?
Yes.
Face down,
Yes.
handcuffed,
Yes.
and as applied here on a hard surface, on the pavement, correct?
Yes.
Right. And so if we're talking about that as the prone, you're calling it prone control,
Yes.
and I use it interchangeably with prone restraint.
I
You
think
accept
they're the
that
same.
term? Okay. So I'll refer to it as a prone restraint. Mr. Floyd is face down, handcuffed behind the back, correct?
Yes.
And at some point, the defendant is on top of him. Is that right?
I think he had his knee on him. I'm not sure if I would describe that as being on top of him.
If I may publish to the witness Exhibit 17. And so, as shown here in Exhibit 17, you're able to see the exhibit. Is that right?
Yes.
All right. And you see that the defendant has his knee on top of Mr. Floyd. Is that correct?
I see his knee in the vicinity of the upper back and neck area.
Is it on the top or the bottom of Mr. Floyd?
It's on his back. Top being top of the head, or
You tell me, is it on the top, the bottom, the side? Where is his knee?
I see his knee on the upper spine and neck area.
Is the upper spine then on the top?
Okay, we can use top.
Okay, you would agree with me then?
Yes.
Okay. And so the defendant is on top of Mr. Floyd.
His knee is on top of his.
And you can't see where his other knee is in this photograph, is that right?
That's correct.
But you have reviewed the body-worn camera footage, correct?
I have.
And you've looked at the other exhibits that have been submitted in this case, or no?
Most of them.
Okay. And so you're aware that now what we're looking at here is the defendant's left knee on top of Mr. Floyd, correct?
Yes.
Are you aware at this point in time that the defendant's right knee is also on top of Mr. Floyd?
I believe it was on his arm or to the side of his body.
You believe it was on his arm?
Yes.
Okay. On top of him, though, right?
Yes.
Okay. And so, to answer my question, the defendant is on top of Mr. Floyd on Exhibit 17. Is that right?
Again, when I say on top, I think he's laying his complete body on top of Mr. Floyd. What I see is the knee positions.
Okay. Both knees on top of Mr. Floyd.
Yes.
Okay. And also, are you aware that the defendant weighed approximately 140 pounds at the time this took place? Were you aware of that by your review of the records?
Yes.
And in your experience, does the clothing and equipment that the defendant is wearing in Exhibit 17, could that add some amount of weight to the defendant?
Yes.
And that would then increase the amount of pressure or force being placed on Mr. Floyd at this time. Is that right?
It could.
Okay. And so looking then at Exhibit 17 and just starting with the fundamental premise of your testimony that what we're seeing here is not a use of force, I need to ask you if you believe that it is unlikely that orienting yourself on top of a person on the pavement with both legs is unlikely to produce pain?
It could.
What do you mean it could? Is it unlikely to produce pain, or is it likely to produce pain?
I'm saying it could produce pain.
It could.
Yes.
And if it could produce pain, then, again, just looking at your premise, if it could produce pain, then it would be a use of force, wouldn't it?
If the officer's intent was to inflict pain, that would be use of force?
Not the officer's intent, sir. What you said is that it was unlikely to produce pain, and that's why it wasn't a use of force. You now just said that it could produce pain. And so, regardless of the officer's intent, if this act that we're looking at here in Exhibit 17 could produce pain, would you agree that what we're seeing here is a use of force?
Shown in this picture, that could be a use of force.
Okay. If you would take that down, please. And sir, I'd like to talk to you a little bit about positional asphyxia, if I'm to understand your testimony about positional asphyxia. This is something that you're familiar with, is that right?
Yes.
This is something that you've taught in courses to budding officers, I'm assuming, the dangers of positional asphyxia?
Yes.
And in positional asphyxia, is it true that positional asphyxia is a result of some oxygen deprivation? Is that right?
Yes.
And that is as a result of a chest cavity, the inability for the lungs to expand. Fair?
Yes.
And in positional asphyxia, as understood in law enforcement, can be a result of having your chest, your body weight on the ground, right, in the prone position. Your own body weight, the subject's own body weight.
That could, yes.
That could cause positional asphyxia, just the body weight itself.
If the person is extremely obese.
Sure.
If you or I were to lie with our hands cupped behind our back on the ground, I don't think either one of us would be prone to positional asphyxia.
Well, I will take that as a compliment, just for the purposes of argument here. But there can be instances, certainly, in which a person, by nature of their own body weight, could experience positional asphyxia. True?
It's possible.
Okay. And things that could, further exacerbate or contribute to that could be the use of restraint, correct? The handcuffs behind the back.
Yes.
And additional pressure as well. So you being a non-obese fit person, right, if someone was pressing down on you, that would sort of take the place of excess body weight, and that could contribute to positional asphyxia. True?
It's possible.
And if the pressure, obviously the greater the pressure being exerted, the more of a potential danger of positional asphyxia. Fair?
Yes.
And the dangers of positional asphyxia due to being restrained in the prone position is a known risk. Is that right?
Yes.
And it's something you know about, true?
Yes.
It's something you teach in your courses, correct, in training?
Yes.
And this is something you've been in law enforcement, did you say since 1972?
For 79 years. Excuse me, 29 years.
Okay, 29 years. At what point did you become aware of the dangers associated with positional asphyxia?
Probably late 80s.
So looking over 30 years that you've been aware of the dangers of positional asphyxia, right?
Yes.
And would you agree that that's something that's commonly understood in law enforcement, that this is a known risk?
Yes.
So this is not new information.
No.
And there are ways to mitigate against the risks of positional asphyxia that are known to law enforcement. Is that right?
Yes.
And I think what you testified to is the side recovery position. Can you describe the side recovery position?
So when a suspect is handcuffed, you just pull them to their side and have them tuck their knees up, kind of like a fetal position almost.
Like a fetal position. Right. And so you've also been a defensive tactics instructor, correct?
Yes.
And you've been certified as such, right?
Yes.
Are you aware of how one might put somebody in the side recovery position?
It's fairly simple to do. Just pull them to their side.
Okay. Does it take a long time?
No.
So it's simple, it's fairly quick, and in your opinion, it alleviates or could alleviate against the dangers of positional asphyxia. True?
Yes.
Now, I know that you reviewed various MPD policies in connection with your review of this case. Is that right?
Yes.
And getting back to the issue of whether what we saw in Exhibit 17 at that particular time was a use of force, are you aware of how the Minneapolis Police Department defines force?
Not specifically, no. I would have a general understanding of it.
Generally, would you agree, or based on your review, would you accept that the Minneapolis Police Department generally defines force to include restraint?
It can.
Particularly if it's restraint that could result in some sort of injury or pain.
Yes.
Fair? Okay. And so you would agree then, just as we are at this point in your testimony, that what we saw in Exhibit 17 would at least fit within the Minneapolis Police Department policy of a use of force. Fair?
Yes.
And a reasonable police officer would adhere to the policies of their own department. True?
Yes.
In your analysis of how, under the Graham factors, how you're going to go about a force review, you indicated that one of the things that you look at is the severity of the crime. True?
Yes.
And severity of the crime is something that, would you agree, the label of the crime, whether it's a misdemeanor or a gross misdemeanor in Minnesota or a felony, isn't as important as the underlying conduct involved in the crime?
I agree.
So a felony level bad check may, from a use of force standpoint, be less serious than a misdemeanor domestic assault. Fair?
So by the nature of the terminology of the crime, I agree. But obviously a domestic violence case is a serious and a potentially violent environment.
And really, maybe that wasn't an artful question, but that's what I'm asking. In this case, the misdemeanor, what's labeled as a misdemeanor assault, would, from a use of force perspective, be more serious than, say, writing a bad check, but at a felony level.
It could, yes.
And you're aware that in this case, the initial call that the officers were responding to was a counterfeiting allegation or forgery allegation, passing a fake $20 bill, right?
Yes.
And could you agree that in terms of the range of criminal offenses, this would be at a fairly low level from a use of force perspective?
Yes, but again, as I mentioned earlier,
Well, what I was asking is if you could agree And I'll give you a chance to explain if you want, but you would agree that in terms of the range of different criminal offenses that are available, a counterfeiting call over an alleged fake $20 bill is on the less serious side.
Yes.
And I think what you probably were about to say is that, but that could change, right?
And again, it's all about the contact and the resistance of the suspect.
Right. Which is completely different than the seriousness of the underlying offense. That's why I stopped you. I didn't want to be rude, but let's just keep this in that analytical framework for now. Seriousness of the offense, not the response, because we'll get to that, the response of the subject.
Okay.
And would you say, would you agree with me that the response of the subject, the activities of the subject to the officer on the scene, as probably the operative important facts here, right? That's what you need to look at.
Yes.
So in terms of the seriousness of the crime, that's not as important. Let's take a look at the imminence of the threat. You discussed imminence of the threat. Officers have to assess that. Is that right?
Yes.
And could you please, for the jury, explain in your words what you mean by threat? What is a threat?
You look at a person and you can't see their hands. They have their hands in their pocket. That could be a threat that in their pocket is a gun. You look at a person and the way they position their body, angle their body back into maybe a confrontational stance. That could be a threat.
All right. So right now I have both my hands in my pocket, and I'm trying to be confrontational. I don't know if I look confrontational, but am I a threat?
If I was walking up to you on the street and it's going to be reasonable suspicion that you have committed some type of criminal activity, I would, from a position of cover, ideally, tell you to take your hands out of your pockets.
Would you agree that there's a difference between a threat and a risk?
Yes.
And so really any person can present a risk, right?
Yes.
Someone could have their hands in their pocket and unexpectedly have a weapon. True?
Yes.
Or not.
Or not.
That's a risk. But would you agree that a threat is when I would be doing something to show some sort of intention to cause you harm? Balling up my fists, approaching you in an aggressive manner. That would be a threat, correct?
Some type of cues, yes.
And would you agree that officers are authorized to use force to respond to a threat?
Yes.
Officers are not authorized to use force to respond to a mere risk. Fair?
Correct.
So there are many different factors that could be a risk versus a threat. Someone who's large in stature, that could be a risk. True?
Good.
But that's not in and of itself a threat, is it?
No.
You can't use force on someone just because they're large. True?
That's correct.
The use of drugs or intoxicants, that could be a risk factor. True?
Yes.
And on that subject, with respect to what a reasonable officer understands about the use of drugs and alcohol, controlled substances, there's a whole range of drugs out there, right?
Yes.
And there's a whole range of drug users out there, correct?
Yes.
And there are some drugs that could cause someone to become aggressive, true?
Yes.
And there's some drugs that can cause the user to become somewhat sedate, true?
Yes.
And so just hearing that someone is, quote, on something, that is not necessarily a threat to the officer, correct?
Unless there's behavior that makes the officer believe that the person's drug influenced.
Agreed. If there's behavior that they're drug influenced or behavior that they're going to be doing something threatening to the officer. Because there's a difference, right?
Sorry, I missed something.
I'm sorry. There's a difference between someone manifesting behavior that they may be using drugs or manifesting a behavior that they're going to threaten you, right?
Again, but the manifestation of the drug influence could pose a threat.
Okay. But, one manifestation of drug influence is that somebody's passed out, right?
Yes.
That probably does not constitute a threat to you, does it?
No.
That's more of a vulnerability of the person who's using the controlled substance, right?
Yes.
So if someone is, quote, on something in and of itself, that is not a justification to use force. True?
True.
And if the person who is on something is of large size, those two things combined, those two risks together combined, those don't justify the use of force, do they?
No, there need to be a third component, that is the actions of the suspect.
Right. The behavior of the subject, what they did. Fair?
Yes.
Also, just in terms of the decision of an officer to use force, that is driven by the behavior of the subject, correct?
Yes.
The decision to use force on a subject is not dependent upon what some third party over whom the subject has no control and is not directing is doing, correct?
I'm not sure if I understand the question.
Let's say that you're distracted by something Mr. Nelson is doing. Let's say maybe he's even threatening you. That's not a justification for you to use force against me, is it?
No.
Because I certainly have no control over Mr. Nelson, right?
Correct.
All right. And so if there are, for example, in the instance of a bystander, if a bystander is doing something that an officer finds threatening or irritating or distracting or annoying, those activities don't justify a use of force against someone who is not directing those activities. Fair?
Yes.
All right. It might explain the officer's state of mind in a particular moment, but it's not a justification for the use of force. True?
I agree.
Okay. You talked about situational awareness, and situational awareness is something that is important for, I think your testimony was anyone, and we can agree with that, right?
Yes.
But in particular, situational awareness is something important for an officer, a reasonable officer to have, correct?
Yes.
And that situational awareness has to include really under Graham all the facts and circumstances, the totality of facts and circumstances that are presented to the officer at the time. True?
Yes.
And in looking particularly at the behavior of the person upon whom force is being applied, it's important that the officer is situationally aware of the condition of the subject, correct?
Yes.
Because if the subject does something aggressive, they may need to adjust their plan in the use of force, correct? Their application. Yes. But if the subject is manifesting compliance or a medical condition, illness, the officer needs to be situationally aware of that as well. Fair?
Should.
Do you agree, in having read the training materials and you're aware of MPD policy, and I'm assuming you've listened to some of the testimony in this case, as an expert you're allowed to do that?
I listened to 2 testimonies from the use of force experts.
All right. Do you agree with the proposition that in law enforcement, once somebody is in your custody, they're in your care?
I agree.
And in fact, that's a MPD policy and training, in your custody, in your care, correct?
Yes.
And situational awareness, then, would you agree, sir, that includes being aware of the subject's medical condition?
Yes.
Particularly if they're exhibiting signs of distress.
Yes.
Loss of consciousness.
Yes.
Inability to breathe.
Yes.
Loss of pulse.
Yes.
All of these things a reasonable officer should take into consideration when determining whether to escalate force, de-escalate force, or remain the same, correct?
Yes.
Now, would you agree, sir, that the application of the use of force must be reasonable at the start and at the end? True?
I agree.
And at all points in between?
Yes.
And if there's ever a point at which the use of force becomes unreasonable, right, that it must stop
Or de-escalate.
or de-escalate. It must de-escalate to a point of being reasonable, correct?
Yes.
Because that's really the standard, is that of reasonability, right?
Yes.
Yeah, and in terms of proportionality, you've read the materials, you've studied the MPD policies, you're familiar with the MPD Defense Tactics and Control Guide, the continuum, use of force continuum?
Yes.
Okay. And you would agree that that continuum, which we've all seen, is a tool that an officer can use to make some kind of a rough approximation of what is a proportional response. Correct?
Yes.
You would agree, based on your review of Minneapolis Police Department policy, that the sanctity of life and protection of the public, those are the cornerstones of Minneapolis Police Department's use of force policy. True?
Yes.
In your review of the Minneapolis Police Department manual, the use of force manual, you received a copy of the manual, I'm assuming? Use of force?
5-300?
That's correct, 5-300.
Yes.
In your study of Minneapolis use of force policy 5-300 series, did you see the phrase or term one-upsmanship anywhere in this policy?
No.
So you would agree that one-upsmanship is not the cornerstone of Minneapolis Police Department's use of force policy. It's protection of the public and the sanctity of life. True?
And I use the phrase one-upmanship to describe how the standards of police training throughout the country are.
You're using one-upmanship to describe the concept of proportionality. True?
Yes.
And one-upsmanship is, I guess if that's an accurate description of what you're trying to express as far as proportionality, wouldn't that suggest, what is the limit to the one-upsmanship that an officer can do?
As I described earlier, that if a person tries to strike you or kick you, that the officer doesn't have to respond with their own punches or kicks. They can respond with a better tool, which would be an impact weapon or a taser or pepper spray. If the suspect were to grab hold of the officer's baton or taser, then the officer may find themselves in imminent threat and respond with potential deadly force.
Right. And I think the examples you used were strike you, stab you, shoot you, were some examples that you were talking about in terms of one-upsmanship, but that wasn't the answer I was looking for. In terms of one-upsmanship, isn't what the officer is always limited in their response by the Graham versus Connor standards of reasonableness, right?
True.
And so whatever step the officer takes to either escalate or de-escalate, it must be objectively reasonable. Correct?
I agree.
And that's why someone who is not resisting, who is being compliant, that's why that person cannot have any force at all exerted against him. Is that right?
I don't agree with that.
If a person is not resisting and is not non-compliant, so let me phrase it better, compliant, that doesn't, officer's not justified in using force if they're being complied with.
So they'd be using control if the suspect's in their custody.
Right. And control, under your definition, like if we're looking just at pure control, that is a restraint that's not likely to inflict pain, correct?
Yes.
That's control. But you've agreed that Exhibit 17, what we saw here in this case, was likely to produce pain. True?
It could.
And so if someone is not resisting and they're compliant, the use of something, control as you put it, that could produce pain is just not justified, is it?
No.
And we talked about the use of force needing to be appropriate reasonable from the beginning to the end, and at all points in between. Is that right?
Yes.
And the officer must reassess the situation, must reevaluate the situation, must be taking in information. Is that right?
Yes.
And that can include information from the suspect, the person upon whom they're using control, correct?
Yes.
That could be information that they're getting from other sources, for example, fellow officers. True?
Yes.
If a fellow officer makes some comment or assessment as to the condition of the subject, a reasonable officer takes that into account. Is that right?
Should.
And that information we use to factor in to reassess the situation to determine whether or not force should be escalated, de-escalated, or discontinued. Fair?
Yes.
And you would agree, we were talking about the threat assessment, you were talking about stabbing, striking, shooting. You agree that based upon your review of the evidence in this case, there was no stabbing attempt by Mr. Floyd, correct?
Correct.
He wasn't trying to shoot anyone, correct?
Yes.
All right. And we should talk about the specific circumstances here of what happened on May 25, 2020. Would you agree, as a general premise, that Mr. Floyd was handcuffed, restrained in the prone position for approximately 9 minutes and 29 seconds?
Yes.
And during that 9 minutes and 29 seconds, did you note any significant difference in the manner in which Mr. Floyd was restrained?
No.
Did you note any differences in the manner in which Mr. Floyd was acting during that entire restraint period from the first point to the 9:29? Did you notice any differences with him?
Yes.
Okay. For example, when he first was placed prone on the ground, he was speaking, correct?
And actively resisting, yes.
And actively resisting when he was proned?
Yes.
Okay. How long did that take place?
I'm not sure. I'd say a couple minutes.
A couple minutes that he was actively resisting?
Yes. Struggling against the officers.
Okay. All right. Well, let's talk about the point when when the restraint of Mr. Floyd first began. And I'd like to show you a clip from Exhibit 127, which is a composite of the King body-worn camera and the Frazier video. And that's going to be starting at 2019-09, which can we agree is around the beginning of the restraint period, based on your review?
I was looking for a screen. Sorry.
Oh, I'm sorry.
I missed that question.
All right. The King body-worn camera. Okay. Right around the time of 2019-09, would you agree that this is right around the beginning of the restraint period?
I'll have to go with your approximation on the time.
And when we pull up the clip, why don't you pull up the clip and we publish it and hit pause right away. All right. So you can see the notation on the top of the screen at 2019-09.
Yes.
Would you agree that that's the beginning of the restraint period, is towards the beginning of the restraint period? Okay. You agree?
I'm not sure, but I'll take your word for it.
All right. Well, why don't we just watch it? And this is going to go through 2019-60.
On the ground.
And so right around 2019-09, right, when we first saw the clip, Mr. Floyd was standing or kneeling by the squad car. True?
Yes.
And did you hear what Mr. Floyd said when he was kneeling at the squad car?
Thank you or something to those lines?
No, I want to back you up a little bit just in terms of situational awareness. And you're aware that the defendant received many hours of paid training by the Minneapolis Police Department, correct?
Yes.
Right around 889 hours, correct?
Sounds about right.
You familiar with crisis intervention training and what that is?
Yes.
You're aware that the defendant took a 40-hour course in crisis intervention training?
Yes.
And that generally is education to make people aware of different impediments to compliance, such as mental illness or intoxication.
Yes.
Anxiety would fit in there, correct?
Could.
Perhaps claustrophobia.
Could.
Right. And when Officer Chauvin, the defendant, first approached the vehicle, and this was before Mr. Floyd went in right in the back, when he first got on the scene, through Officer Chauvin's body-worn camera, you could hear Mr. Floyd saying that he had anxiety and claustrophobia, correct?
Yes.
And then there was a struggle, and you observed the struggle in the back of the car when the officers forced Mr. Floyd in the back of the car, right?
Yes.
And then when he came out, he was kneeling right around the time we were looking. He was on his knees. He's handcuffed, right?
Yes.
And he says, "Thank you," right?
Yes.
And it was after that point that Mr. Floyd was then pushed over by the officers onto the ground, correct?
Yes.
And at the time he was pushed onto the ground, just taking note of his body position, when he was initially pushed onto the ground, would that have qualified as a sort of a side recovery position?
We'd have to back it up, and I'm not sure how long he was in that
Please do.
position.
Right. And so when he was were you able to see that?
I was.
All right. So when Mr. Floyd was initially brought from his handcuffed position on his knees to the ground, right, he was in effectively a side recovery position. Fair?
Momentarily, yes.
And then he was taken out of the side recovery position by the officers, and then after that point placed in the prone position. True?
Yes.
And so right after this clip runs, we see Mr. Floyd in the prone position. Correct?
Yes.
Face down on the ground, handcuffed. True?
Yes.
And the defendant and Officer King and Officer Lane then thereafter all took part in restraining Mr. Floyd in the prone position on the ground, based on your review, correct?
Yes.
And you were able to see then from Exhibit 17 that the defendant had one knee at least on Mr. Floyd's body, on his neck, in the neck back area, correct?
Yes.
Okay, on top. And you could see that he had his other knee also, I believe you said, near his arm, but it was on his back, correct?
I really couldn't tell from that picture. I took that from the snapshots of the body-worn cameras.
And so when you say that, you're agreeing that the defendant was on Mr. Floyd's neck and back, at least at some portions of the restraint. Fair?
I would say upper back in the proximity of the neck, and then his right knee was towards more of his rib cage.
On top of him, though, correct?
Yes.
Adding to the pressure. Fair?
Could.
Sir, I'd like to show you, just for a little more clarification, Exhibit 240, which has been received into evidence, and this might provide a better view. Okay. And so you testified just a moment ago that you thought that the defendant's knee was where?
Upper back and neck.
Okay. And so would you agree on placing a circle? Would that be Mr. Floyd's back, upper back?
That would be his upper back.
Okay. And I'll just place another circle. That's the defendant's knee.
It is.
His left knee. That's above the area that you've identified as Mr. Floyd's upper back, isn't it?
Yes.
His left knee is on Mr. Floyd's neck in this picture, in Exhibit 240, isn't it?
In this picture, yes.
Okay. Now I'd like to talk about his right knee. And you can see Mr. Floyd's arm, where I'm drawing, correct?
Yes.
And you can see the handcuffs, correct?
Yes.
Okay. And this is the defendant's right knee, correct?
Yes.
Would you agree that the defendant's right knee is on Mr. Floyd's lower back?
Looks like it's on his shoulder blade area to me.
Okay, so the shoulder blade area would be that. Would you clear that, Your Honor? I seem to have trouble here. I appreciate that. So the shoulder blade area, then, I guess that would be Mr. Floyd's upper back?
Yes.
Okay. So you would agree, based on Exhibit 240, that the defendant's on his left knee is on Mr. Floyd's neck, his right knee is on Mr. Floyd's back, correct?
Yes.
And I believe your testimony earlier was that you've watched the entirety of this body-worn camera videos, true?
Yes.
And you would agree with me that there's a wealth of body-worn camera video footage in this case, true?
Yes.
And milestone video and surveillance video and bystander video, correct?
Yes.
So you're able to view, as an expert, the conduct here from multiple angles, true?
Yes.
And so with that sort of, I guess, redundancy built into the record, does that alleviate some of the concerns or considerations I think you were testifying to on your direct examination regarding how cameras react to light?
Yes.
Okay. So this exhibit 240 is actually an image taken, you can see it's at 20:19:27, that's about 13 seconds after the defendant placed Mr. Floyd in this prone position. You agree?
He was one of the three that put him in the prone.
Sure. After, and so we'll say, after the defendant and the two other officers put Mr. Floyd in the prone position, restrained on the ground, correct?
Yes.
All right, and then the first video that we play would demonstrate then that this restraint that we're talking about, which you said was a controlled restraint, or what was the term you used?
Prone control.
Prone control. That began around 2019-14. Fair?
Okay.
Okay. And I believe you testified that from the beginning to the end, you did not see the defendant's relative position on Mr. Floyd's body meaningfully change. Did you?
Can you rephrase the question?
Did the defendant get up from the point in which the prone restraint began and the prone restraint ended?
Did he get up?
Did he get up?
No.
Right. Did he let up off of him any pressure?
It appears that his body position changed, and he was putting more weight over his calves as the restraint continued.
And are you able to identify, based on your own review, because I know you've looked at this, correct?
Yes.
And I'm assuming you've looked at it a lot in preparation for testimony today, correct?
Yes.
Are you able to point to any particular portion of the video record in which you say that the defendant shifted his weight more towards his calves to take pressure off?
I would have to see the 14 body camera snapshots, and then we can focus on those.
Now, sir, I'm going to show you another portion of the body-worn camera video, and that's going to be at, it's been received as Exhibit 127. It's a composite of King's body-worn camera and the Frazier video. And we're going to start at 20:23:11. It should be Exhibit 127. It should be composite of King and the Frazier video. Anyway, we should be starting at 2023. This starts at 23:10. And if you'd play this portion, please.
How long y'all gonna hold him down? No, y'all gotta put on. Right.
And then, just having reviewed that video, I'd like to show you what's been marked as demonstrative exhibit 947. 947. All right, so in demonstrative exhibit 947, you see it's a still frame captured from composite, I guess, or the exhibit 15, which has been received into evidence at the time, it's non-military time, but it's 8/23/14. And this is roughly corresponding with the clip I just showed you. Can you show, do you see the defendant's, the foot on his left leg?
Yes.
Okay. And do you see how it's slightly off the ground?
Yes.
Okay. Now, you would agree that, given the orientation of the defendant's foot at this particular moment in time, there would be more pressure placed on Mr. Floyd's neck and back. True?
It's possible.
It's more than possible, isn't it? I mean,
So the reason why I say possible is that Mr. Floyd's movements could have, in that moment, taken Mr. Chauvin's foot off the ground.
Let's take a look at that clip we just watched again, please.
Restraint? They are.
Yep.
How long y'all gonna hold him down? No, y'all gotta put on. Right.
Are those the movements you're talking about that could have moved his foot up?
Yes, and I saw the officer reach out for a low balance by supporting his left hand up against the back of the squad car.
And the balance issue is important because when you place yourself, both knees on a person, that's not a very good balance point, is it?
It depends.
Well, apparently it wasn't here if the defendant was trying to balance himself against the car, correct?
Or he's just responding to Mr. Floyd's movements.
But as you saw in the portion that you looked at, the defendant's body weight was not being supported by his foot because his foot was off the ground, correct?
At that moment that that picture was taken, yes.
And that would increase the pressure on Mr. Floyd, whether
Like I
he's
said
moving
earlier,
or
it
not.
could be in response to his movement.
Whether it's in response to his movement or not, the question is, would it increase the pressure? Would it increase the pressure?
I don't know.
All right. We've discussed a little bit about the defendant's initial use of force to restrain Mr. Floyd. Right. And I'd like to discuss now what happens next. As you've analyzed all of these videos, but it's important that we get the full scope of your opinion here. So we're going to go back to Exhibit 127 and begin at clip 2019-23. And if you can start playing now.
Grab that. Get him. Jesus Christ. I can't breathe. I can't breathe. Thank you. I can't breathe. Stop moving.
Thank you. So during that segment, that was about 9 seconds. The beginning of it was about 9 seconds after Mr. Floyd was placed in the prone position. Would you agree?
Yes.
And during that period of time, you heard Mr. Floyd say multiple times, "I can't breathe." True?
Yes.
Did you count how many times?
No.
I counted 6. Would you have any reason to dispute that?
No.
And obviously the defendant would know, a reasonable officer would know, that this prone position could present a danger of positional asphyxia. True?
It's potential.
And that it's important then, in terms of situational awareness, to not only be aware of that training and prior knowledge, but to pay attention to what the subject is saying, correct?
Yes.
And the subject here is saying multiple times, "I can't breathe," correct?
That's correct.
Now, I think your testimony earlier said there can be times in which people can say they don't breathe and don't mean it, right?
Yes.
Might be faking it, I guess, right?
Good.
But context is really everything, isn't it?
Can be.
Because part of the reasonable police officer analysis assumes that you have a reasonable person applying the standards and using a little bit of their common sense. Fair?
Yes.
All right. And so if I have, I'm standing here talking to you normally in a normal tone, in a normal voice, and I tell you, "I can't breathe." I'm standing here, I'm talking to you, you might have reason to doubt me, correct?
Yes.
But in a situation where we have here, where you're actually physically on top of someone, in a position which, based on your training and based on your experience and based on your knowledge, could cause positional asphyxia, that's a different context, correct?
Yes.
And in that context, a reasonable police officer would at least acknowledge and consider the possibility that what they're doing is causing a problem, wouldn't they?
Where you would interpret what Mr. Floyd is doing while he's making the statements, and it appeared to me with that video that he was still struggling.
Struggling or writhing?
I don't know the difference.
Well, would a reasonable police officer on the scene consider whether somebody is actively resisting or writhing on the ground because they can't breathe?
I think it'd be reasonable for the officer to take what Mr. Floyd had been doing prior to that and still consider that he was struggling.
And prior to that, you would acknowledge that there was a physical struggle, correct?
Yes,
Physical struggles can be exhausting, correct?
they can.
That's exhaustion is based on your training and your knowledge and your experience, another potential risk factor associated with positional asphyxia, true?
Can be, yes.
It can complicate things, true?
Yes.
As can intoxication, true?
Alcohol or drug?
Let's start with alcohol.
I don't know.
Okay? Drug intoxication could also be a risk factor with positional asphyxia, true?
It can.
And when we talk about some of the different factors and things that would known at the scene, a reasonable police officer in the defendant's position would have taken those factors into account as well, true?
Yes.
From his vantage point on top of Mr. Floyd, fair?
Yes.
We take our technology break at this point, Judge?
Yeah.
All right.
Take our 20-minute break.
Come back at 3:20. All right, still under oath.
Okay.
Mr. Slisher, you may continue.
Thank you, Your Honor. And sir, I'm going to ask you some questions just to see if we can skip through some of the video as well. You would acknowledge, you testified about the bystanders who had gathered by. Is that right?
Yes.
And I think you defined a crowd in the law enforcement parlance as more than two people.
Gathered for a common purpose.
I always heard three is a crowd, but it's two people or more. I guess that'd be three. So that would constitute a crowd. Not all crowds are, of course, threatening. Is that right?
Correct.
Or even distracting, correct?
Not all crowds, no.
And in fact, let's talk about the specific bystanders here. You would agree that at the time that the restraint period began, there really were no bystanders, right? There were no bystanders there. True?
I think there was one gentleman that was there pretty much the whole time.
Are you talking about Charles McMillan?
I'm not sure what his name was.
61-year-old. Well, let's take a look at Exhibit 49 at it's Officer Tao's body-worn camera at 2019-23. If you would publish that, please.
I can't breathe. I can't breathe. I can't breathe. I can't breathe. Not moving.
And at that time, then you see the camera had panned out into the street, and there was the one gentleman that you'd referred to, correct?
Yes.
And did he appear to be saying anything,
Not that I heard, no.
doing anything,
No.
threatening,
Didn't appear to be, no.
major risk factor?
No.
And during that period of time, you heard Mr. Floyd repeating that he can't breathe, correct?
Yes.
And so a reasonable officer in the defendant's position at that time shouldn't have been at least distracted by Mr. McMillan. Fair?
Yeah, that's fair.
Okay. Now, if we could go to a little bit forward, take a look at Exhibit 127, starting at 2021-28. And we'll play that through 2021-59.
Please, Lord, let him breathe. I can't breathe.
You're doing fine. You're talking fine.
I
Let
can't
it
breathe.
breathe, Lisa, man.
I can't breathe.
I've been
I
checking
can't
him out.
breathe.
Breathe, look at man. One of my homies down here, anyway, the back road.
I'm about to die this thing.
Relax.
Man, I can't breathe my face. Just get up. Oh.
What do you want?
I can't breathe. Please, the knee in my dick. I can't breathe shit.
Bro, get up.
All right, and so, sir, at this point, the clip that we just heard, the restraint is continued, fair?
Yes.
Great. And this then, as he's talking, you can hear Mr. Floyd at least expressing that he's in some kind of distress, fair?
Yes.
Indicating that he can't breathe.
That's what he's saying.
And of course, the defendant is on top of him, true?
Yes.
And so in the context here, that might be a reasonable police officer might tend to believe him, correct?
I'm sorry, believe.
Mr. Floyd.
That he
He's
can't
saying
breathe?
he can't breathe, and the defendant is on top of him on the hard pavement. In that context, a reasonable police officer might tend to lend that some more credibility than, say, if he was shouting it from across the street at normal tones.
It's possible.
And at this point, did you see anyone, any bystanders in the crowd?
The clip really wasn't showing much. I did see two people look like Officer Tao engage with one person, tell him to get back on the sidewalk.
Well, let's take a look at around the same time, which is Tao's body-worn camera, which is marked as Exhibit 49 at 2021-18. Be about 10 seconds earlier than the clip I just showed you. If we could play that, please.
Please, man, let him breathe.
Relax.
I can't breathe.
You're doing fine. You're talking fine.
I can't breathe.
Breathe, Lisa, man.
I can't breathe.
I've been
I
checking
can't
him out.
breathe.
He's talking, so he's breathing. Breathe, look at died. Man, went back for you.
My brother just died yesterday.
Relax.
Man, I can't breathe my face. Just get up.
What do you want?
I can't breathe. Please, the knee in my neck. I can't breathe shit.
Well, get up, get in the car.
All right, and so where we ended, we just heard it would have been the 61-year-old Charles McMillan saying something to the effect of "Get up and get in the car," right?
Okay, I heard that.
All right, and then you saw some other bystanders, correct?
Yes,
And those bystanders appeared to be a ways away from Officer Tao, correct?
on the sidewalk, yes.
On the sidewalk, and they were a couple of teenage girls, correct?
I saw one woman, I thought I saw a man, and they're both recording.
Recording. There was someone in a hooded shirt with a phone, correct?
Yes,
All right, and then there was someone who was in a white T-shirt with a phone.
yes.
And did they appear to be saying anything?
No,
And so it would be fair to say that people on the sidewalk at that point wouldn't have been doing anything that could have been distracting a reasonable police officer at the scene, correct?
at that point, yes.
All right, and then I'd just like to show you, it's been marked, it's Exhibit 127 at 20:22:22 through 20:22:36, further in the restraint.
My stomach hurts. My neck hurts. Everything hurts. There's water or something. Please. Please.
All right, and so that clip started about 23 seconds after the last clip I just played you. You were able to hear that?
Yes,
All right, and you heard Mr. Floyd saying that he couldn't breathe, correct?
yes.
You heard Mr. Floyd saying that his stomach hurt, is that right?
I wasn't listening for that. I heard him ask for water, I think.
You heard him ask for water?
Yes.
Would you believe me if I told you that what Mr. Floyd said was, my stomach hurts, my neck hurts, everything hurts?
I heard everything hurts, yes.
And that would be some sort of expression of pain, fair?
You could?
And a reasonable police officer in the defendant's position would have heard that, correct?
I believe so.
From his position on top of Mr. Floyd. True?
It's possible.
And the bystanders who were there, again, you couldn't hear any noise interference or anything like that. True?
Not then, no.
All right. And so would it be fair to say that there was nothing that the bystanders were doing at that moment in time that we just watched that would have been distracting or preventing the defendant from attending to Mr. Floyd?
Not during that video clip, no.
Okay. And I'm sorry, did you or did you not hear Mr. Floyd say that his neck hurts in that clip?
I didn't hear that.
Did you note that at all in your analysis of this case? At any time when you listened to the body-worn camera, when you listened to the bystander video, when you reviewed the facts and evidence in this case, at any time do you recall noting Mr. Floyd saying, my neck hurts?
I heard it. I didn't necessarily note it.
Okay. Because your testimony was premised on this not being a use of force because there was no pain involved, right?
Yes.
But you didn't note that
No.
fact? All right. In response to Mr. Floyd's complaints for pain, you heard a voice. Did you recognize that voice responding to Mr. Floyd?
In this last video clip?
Yes.
I didn't, no.
Did you hear an officer say, uh-huh?
I heard somebody say that.
And based upon your review, you've reviewed all of this, correct?
Yes.
You've reviewed footage in which the defendant can be seen and can be heard speaking, correct?
Yes.
Right. Were you able to make out the person who said uh-huh as the voice of the defendant?
So when I looked at this video clip, I thought we were still looking at the focusing on the bystanders, so I wasn't really listening to what the communications were.
I mean, in your own analysis prior to coming to court today, and I don't mean to put you on the spot, but in your own analysis before coming to court today, had you identified that voice that said, in response to Mr. Floyd's cries for pain, as that belonging to the defendant?
Yes, I had.
Okay. And so you would acknowledge that Mr. Floyd was crying out in pain and the defendant was at least acknowledging that he could hear him at the time.
If that's what the aha was in response to.
Okay. Well, was the aha in the reasonable context in which this conversation, if you can call it that, took place in response and immediately after Mr. Floyd's individual cries for pleas for pain or claims of pain?
It was the same time frame.
Yeah. And so my stomach hurts, my neck hurts, everything hurts, right? That's
Yes.
what you heard. And the was the defendant responding.
Yes.
All right, I'd like to take you then to Exhibit 49 at 20:22:22, which is going to be overlapping the period we just saw. I'll just start it, and I'd like you to pause it right away. 20:22:22. All right, if you could hit play, and I'll tell you when to pause. Stop. Okay. And so now at this point in time, you see bystanders, correct?
Yes.
And you would acknowledge that they're not in the street, correct?
Correct.
They're on the sidewalk,
Yes.
right? They're holding cell phones.
Yes.
Right? These are the two teenage girls I was talking about.
Okay.
This is the elderly gentleman I was talking about, Mr. McMillan.
Okay.
Right. They don't appear to be doing anything threatening at that point, do they?
No.
They don't appear to be making any noise at all at this point, do they?
Not that I could hear, no.
And certainly would not have distracted the defendant.
That I can't say.
Well, they're not doing anything and they're not saying anything. So would a reasonable police officer in the defendant's position have been distracted by their non-action?
I think he could have been aware of their presence and maybe start to plan for it.
Okay. But you see in this, at 20:22:27, at least he's looking down at Mr. Floyd. He's talking to Mr. Floyd, at least acknowledging what Mr. Floyd is saying, right?
Yes.
And so while it's possible he could have potentially been aware of them, it doesn't appear he was from at least what we just saw here. True?
Not from this snippet, no.
All right, let's move ahead again then. In Exhibit 43, starting at 20:23:38. If you could publish that, please.
Please.
Roll on the side.
No, stand put where you got them.
Stop. All right, now at that point you could hear somebody in the background, correct?
Yes.
You heard Mr. Floyd, true?
Yes.
His voice appeared slower than before,
Possibly.
thicker than before,
And what?
thicker.
Yes.
Right? You also heard conversation, normal tone conversation between Officer Lane and the defendant, correct?
Yes.
Officer Lane said, roll him on his side, right?
Yes.
And what was the defendant's response?
Something not yet.
No, keep him here,
Okay.
right? And so at this point, Officer Lane is suggesting that they roll him on his side. Would that be consistent with the side recovery position?
Yes.
Okay. And the defendant is rejecting the side recovery position at this point. True?
Yes.
He's hearing his information from his fellow officer, deciding a different course of action. Nothing the crowd's doing is preventing them from having that conversation. Is that right?
Not that I'm aware of, no.
And in your view of the clip that we just looked at, just focusing on the subject behavior, what is Mr. Floyd doing? What was he doing in that clip?
He's becoming more compliant.
Well, is there any non-compliance you were able to see in that clip?
In this clip, no.
And so he's not exhibiting non-compliance, and based on your testimony and your review and the plain video record in front of you, you see that the defendant has not changed his position, correct?
Correct.
He's still applying the same level of force that he did at the beginning of the restraint period, true?
That I can't say.
He's still kneeling on Mr. Floyd, correct?
Yes.
And you're not contending this was some sort of an accidental position, right? He didn't fall down onto Mr. Floyd, and he was purposefully kneeling on him.
Yes.
True? Okay. All right. And so, based on your view, right, of the defendant being on top of Mr. Floyd, up to this point and beyond this point, the defendant did not alter the level of force that he was using on Mr. Floyd, did he?
No.
Even though Mr. Floyd, by this point, had become, as you put, compliant. Fair?
More compliant, yes.
Well, what part of this is not compliant?
So I see his arm position in the picture that's posted.
Right.
That, a compliant person would have both their hands in the small of their back and just be resting comfortably, versus like he's still moving around.
Did you say resting comfortably?
Or laying comfortably?
Resting comfortably on the pavement.
Yes.
At this point in time, when he's attempting to breathe by shoving his shoulder into the pavement.
I was describing what the signs of a perfectly compliant person would be.
So attempting to breathe while restrained is being slightly non-compliant?
No.
No. You're aware, if we could take a look at Tao's body-worn camera starting Exhibit 49 at 20:23:38. And at this point, you see this is Tao's body-worn camera. We see more people here, correct?
Yes.
Right. You still see the teenage girl with the cell phone?
Yes.
She's joined by what appears to be a juvenile female, correct?
Yes.
Wearing a love shirt.
Yes.
Right. Another teenager filming. Is that right? And you see that?
Yes.
And then there's an individual in a hooded sweatshirt standing on the sidewalk, correct?
Yes.
All right. If you could play that.
We're done. You circle.
Okay, we're
like
done.
in a jiu-jitsu move,
We're done.
bro. You try
We're done.
this breathing right there, bro.
Okay.
Like, you don't think that what it is, bro? You don't think nobody understands that shit right there, bro? I trained at the academy, bro. That's some bullshit, bro.
You did. Okay.
Right,
Then
that's
you understand.
bullshit, bro.
All right.
That's bullshit, bro. You fucking stopping his breathing right there, bro.
Okay, he's talking.
Okay. Well, you heard Mr. Tao say he's talking, correct?
Yes.
Referring to Mr. Floyd, right?
Yes.
I guess he was talking, wasn't he?
Yes.
And he said, "I can't breathe," right?
Yes.
And it was even more slow at this point, correct?
Could have been.
And this is well within the restraint period, true?
Yes.
And the individuals here, in terms of the volume you're hearing, you don't hear this person saying anything, do you?
No.
Or her?
No.
Or her?
No.
Or him?
No.
Or him?
I'm not sure of that.
The
No.
gentleman in the blue shirt with the baseball cap.
No. Didn't hear him say anything.
Didn't hear the guy behind the person in the hooded sweatshirt say anything, in the plaid shirt there?
I didn't hear him. No.
Okay. And so the only person that you would have heard say anything is the person in the hooded sweatshirt, correct?
Yes.
And what was he saying?
Something about get off from bro. You don't learn. You don't teach that in the academy. You don't learn in the academy.
He said you're cutting off his breathing, right?
Okay.
Fair to say he was expressing concern.
Yes.
And in this moment, was this crowd a threatening crowd?
No.
All right, I'm going to take you to Exhibit 127 at 2024-18. Please publish that.
In the car by now, bro. He's not resisting arrest or nothing. You enjoying it. Look at you. Your body language explains it. You fucking bum.
It's the whites. They love
But,
them as the
yeah, I
whites.
already know that, bro. I trained with half of these bum ass dudes at the academy, bro. You know that's bogus right now, bro. You know it's bogus. You can't even look at me like a man because you a bum, bro. He's not even resisting arrest right now, bro.
His nose is bleeding.
He's fucking stopping his breathing right now, bro. You think that's cool? You think that?
Okay. During that time period, and I don't know if you heard, did you hear another officer, did you hear the voice of Officer Lane say he's passing out?
I didn't hear that, no.
Did you hear Mr. Lane say that at any point in your analysis of these videos before you came to court today?
About what Mr. Lane or Officer Lane said?
That's correct.
Yes.
Yeah. And so you heard him say at least one occasion he's passing out, correct?
Yes.
And would you accept my representation that that would have occurred around this time during this clip?
Yes.
All right. And other people, bystanders, are saying the same thing, correct?
I heard mostly just what the one gentleman was saying about being a bum and not resisting arrest and things like that.
Right. That the defendant was being a bum and that Mr. Floyd was not resisting arrest, correct?
Yes.
And you just saw the video. You saw Mr. Floyd, what he was doing at that time. At that time, would you agree, and I'll tell you the name of the person, it's Donald Williams. Would you agree with Donald Williams that Mr. Floyd was not resisting arrest at that moment?
Yes.
Mr. Floyd doesn't appear to be conscious at the end of this clip, does he?
I can't tell.
And you're certainly not as close to him as the defendant was in that moment, correct?
Correct.
He's not talking, correct?
Yes.
He's not resisting.
Doesn't appear to be, no.
And from this point forward, the defendant remains on top of him in the same position as when he started the restraint period. Isn't that true?
I would say the same general position. I wouldn't say the same exact position.
Yeah, same exact position, same general position. The position is such that he's on top of him, compressing his lungs, compressing his chest against the pavement, right, with his body weight.
It's in a prone control position.
In a restraint. He's restraining, correct?
Yes.
Can't move, right?
Floyd can't move?
Floyd can't move.
No.
He's not moving. He's not resisting. He's not talking. It's not possible, is it?
To do what?
Resist
I think it's definitely possible to resist.
when
It's
you've
just
passed out. He's not doing it here, is he?
not when he's passed out, no.
When we talk about what's possible, let's talk about what's happening in this case. He's not resisting, is he?
And this snippet, no.
Right. And from this point forward, right, from this point until the point at which the EMTs arrive and tap on the defendant's shoulder and take Mr. Floyd and place him onto the gurney. From this point to that point, Mr. Floyd wasn't resisting, was he?
No.
The defendant maintained the same general position.
Yes.
Force must be reasonable at the start of the force, correct?
Yes.
Throughout the continuation of the force and at the end of the force, correct?
Yes.
And you reviewed these videos and you understand that by the time the defendant got off of Mr. Floyd literally could not support his own head. Did you see that?
Yes.
You see the way he moved, the way his head moved when they moved him onto the gurney?
I did.
And a reasonable police officer in the position of the defendant, and that position is the position we see here, on top of him, would know that, right?
Would know
That he's not responsive, that he's not resisting.
I think he would know he's not resisting.
Because the officer said that he wasn't breathing. Said that to the defendant, right?
The officer did, or what the bystander?
Mr. Lane said that.
Can you
Rephrase because I got lost in
I'm sorry. Mr. Lane said that. Mr. Lane said that to the defendant in the prior clip we watched, that he's not breathing. right?
Well, I heard that he's passed out. I didn't hear the not breathing part.
Well, the passed out came from the bystander, right?
I'm not sure.
Did you hear at some point in your review Officer King say that he couldn't find a pulse?
Yes.
All of this would have been known to a reasonable officer in the defendant's position, correct?
Yes.
And the defendant's position is and was and remains, as we see here at this moment, in this time, in this clip, on top of Mr. Floyd, on the street. Isn't that right?
Yes.
I have nothing further.
Mr. Broad, you were asked a lot of questions on, if we could take this down. You were asked a lot of questions on cross-examination about the prone control position. Do you recall that?
Yes.
Can you describe what specifically you mean by the prone control position? What is the placement of the knee relative to the back, neck, shoulders, etc.?
Ideally 45 degrees in between the neck and shoulder blade.
So 45 degrees coming in from the side?
Yes. Angling down towards the lower body.
And where would the shin be placed?
Just below the knee, same thing around the trapezoid area.
So there's a kind of a hard spot in between the base of the neck and the shoulder blades. Is that the area you're talking?
Sustained.
Can you describe by touching your back the area that you're describing?
So the knee would probably end up pretty much on the spine, and the shin would be along the trapezoid.
Okay. And during the course of this, your testimony, you were shown several, short clips of things happening from time to time. Agreed?
Yes.
What's the problem in terms of the analysis by looking at just specific short clips?
Doesn't really show the sequence of events, just shows little highlights of it.
In terms of the analysis, the standard being the totality of the circumstances. Agreed?
Yes.
And so when we kind of pick and choose, does it take into consideration everything that happens or that a reasonable officer would be doing at any particular time?
No.
And what would be another phrase for that?
Kind of picking and choosing.
Like 20/20 hindsight?
Objection, leading, and argumentative.
Sustaining on both.
I'll withdraw. Now, in terms of the when someone is in the prone control position, you testified that you don't consider that to be a use of force, correct?
Correct.
And that's why again?
It's a control hold. So the suspect is controlled, hopefully searched, and all you're doing is putting some minimal body weight to keep their body immobilized.
Does it impact the structures of the neck?
No.
Can a suspect continue to lift up his head, move his head around?
Yes.
Do you observe Mr. Floyd doing that while he's in this position?
Yes.
Did you observe him use his face to try to lift up his body?
Yes.
Did you observe throughout the course of this event, did you observe Mr. Floyd's right arm in various body-worn cameras?
Yes.
Did you observe his veins during that?
Yes.
What did the veins signify to you?
Had strong pulse. He looks very muscular.
Objection, foundation, Your Honor.
Overruled.
In terms of when Mr. Chauvin first arrived on scene, what would have been the first thing Mr. Chauvin would have seen?
The struggle that Mr. Floyd was giving to Officers Lane and King.
And does that come into consideration of the analysis of the continued use of either force or a prone control?
Yes.
How about 1 versus 3? How does that factor into the analysis?
I'm not sure if I understand the question.
Certainly. You've observed the struggle between officers and Mr. Floyd. How many officers were there?
2, and then Officer Chauvin was the 3rd.
Okay. And how many suspects were they attempting to apprehend at that time?
Just Mr. Floyd.
Did Mr. Floyd, did all 3 officers at any point attempt to get Mr. Floyd into the back of their car?
All 3 did.
Were they successful in your analysis?
No.
So does the analysis in terms of, again, the continued use of force or putting someone in a prone restraint include what happened moments before?
Yes.
And so if one person can overpower 3, is that a factor to consider in whether to use a prone restraint or control technique?
Yes, because it takes some of the strength that the suspect may have away from them.
Are you familiar with what we would call the swarm technique?
Yes.
Well, can you describe for the jury what the swarm technique is?
It's where multiple officers will use their body weight to pin a suspect down to the ground.
And the purpose is?
Control.
And at the beginning of the prone position of Mr. Floyd, did you observe Mr. Floyd continue, at least initially, to actively resist?
Actively, and with the kicking motion, active aggression.
So let me ask you, in terms of the concept of active aggression, that's taking a swing or using some force against an officer. Is that correct?
Yes.
Does active resistance have to be violent in order for it to be active resistance?
No.
Are there levels of active resistance?
Sure.
So can you explain how the level of active resistance may change?
So pulling away from an officer would be one example of active resistance. Just muscle rigidity, refusing to let an officer pull your hands away from your body would be another example.
Okay. So there are, like all things, sort of a spectrum of active resistance, active aggression, or passive resistance, right? There's a spectrum of it, right?
Yes.
And during the course of the restraint of Mr. Floyd, do you continue to see Mr. Floyd actively resist to some degree?
Yes, he was struggling.
And how would you describe that within the spectrum of active resistance?
He's a very strong individual, so a lot of that has to do with individual capability. So he was still struggling the efforts of the 3 officers to control him.
A reasonable officer, in terms of making a decision to keep someone in a prone restraint, can take into consideration the actions that occurred immediately before.
Rephrase. Sustain.
Is it possible for a reasonable police officer to? I'll rephrase. I'm sorry. Is the decision to use force or a restraint technique a spectrum similarly?
Yes.
And officers are trained to assess the risk.
Yes.
It's preliminary. Overruled.
And the threat.
Yes.
Those were some questions you were asked about.
They were.
Why is it important to have a suspect in custody under control?
For the safety of the officers and safety of the suspect.
And if a suspect becomes more compliant and less actively resistant, does that eliminate the officer's ability to maintain a restraint?
No.
You were asked several questions about Mr. Floyd stating that he couldn't breathe while he was being restrained. Did you hear those same statements during the struggle inside of the squad car?
Yes.
Did you hear them more than once at that time?
Yes.
Did you hear him state that he was claustrophobic?
Yes.
Would a reasonable officer consider the actions of that person in relation to the words?
Yes.
If a person is saying he can't breathe and continues to actively resist, albeit at a lower level, would an officer, reasonable officer, take that into consideration?
Yes.
You were asked a series of questions about a singular point in time when Mr. Chauvin's his toe came off the ground. Did you interpret that to be an increase in the amount of force applied to Mr. Floyd?
I couldn't tell.
You described in your cross-examination that he had to sort of catch himself on the squad car.
Yes.
Would you interpret that as a lack of balance or an effort to apply a greater amount of force?
I think reaction to Mr. Floyd's body movement made the officer lose his balance momentarily.
Do you think that if you're on two knees, there's nothing underneath you, two knees on the ground, right? Is weight permanently equally distributed between those two knees?
Objection leading and beyond the scope.
Overruled on both grounds.
No.
Do people sort of move around?
Yes.
Do their weights shift?
Yes.
Do you observe that happening in this case?
Repeatedly.
Do you observe Mr. Chauvin or Officer Chauvin relieving some pressure at times when Mr. Floyd moves?
Yes.
Is that consistent with a prone control restraint?
Yes.
You were shown some videos when the first young woman first came and started filming at approximately 20, 21, and 29 seconds. Do you
Yes.
recall that? Did you factor into your analysis the timing of when EMS was called and then subsequently increased to their response rate?
I'm not sure if I understand the question. Sure.
The videos that you watched, some of the videos you watched when Ms. Frazier began filming at 20:21:29, if EMS were called at 20:21:35, code 3, does that factor into the analysis?
Yes.
Why?
Knowledge of the area and the fact that they anticipate the response time is going to be very rapid.
Can you underestimate a member of a crowd or a group of people simply by virtue of their age?
Certainly.
Is it possible that a 17-year-old person can place as an officer in an equal amount of danger?
Absolutely.
You've seen other videos from other officers and you became aware, or did you become aware of the traffic patterns and the number of people driving by?
Yes.
In terms of the position of the officers relative to traffic.
Objection beyond the scope, Your Honor.
Overruled.
How does that, again, factor into the analysis during this time frame?
That would be an environmental hazard since they were almost in the traffic lane and there really wasn't any protective barriers around them.
going to show you one second here. I'm going to just show you one snippet at 20:24:01 from Officer Lane's body camera. Is already in evidence, I believe, as Exhibit 49.
It's hard to come off the ground. We're in a bum right now. You can get him off the ground, bro. You can get him off the ground. You be a bum right now. He enjoying that. He enjoying that shit. He enjoying that shit. He a fucking bum, bro. He enjoying that shit right now, bro. You could have fucking put him in the car right now, bro. He's not resisting the rest of the stuff. You enjoying the shit. Your body language is crazy.
Ending at 20:24:26, did you observe Mr. Floyd's leg in that moment?
Yes,
Would a reasonable officer interpret that to be a form of active resistance?
possibly.
Did you observe, how did you observe Officer Lane push that leg down? Was it gently or forcefully?
Fortunately, it took both his hands.
If we could take this down, Your Honor, for a moment. I'm going to show you what's been introduced as Exhibit 1020, which is the point at which the ambulance and Mr. Chauvin stands up towards the end of this restraint. And I'm going to ask that, this is already in evidence, I'm going to ask for you to make a determination as to where you think Officer Chauvin's knee is.
Looks to be on the left shoulder blade of Mr. Floyd.
So it's fair to say that throughout, we'll just let this finish. Did that appear to be consistent with the prone restraint hold that you described?
Yes.
So if we can publish that to the jury then, just... Would you agree that on the left-hand side it appears that Mr. Chauvin's knee is on the neck of Mr. Floyd?
No.
How about on the right?
No.
So from that perspective, Mr. Broad, does it appear to be consistent with a reasonable officer's use of the prone restraint technique?
Yes.
Is that sort of the problem with snippets?
They don't show the full picture.
Would you agree that well, you tell me, if if a group of people is compliant and passive at one moment, does that mean they're going to be at the next?
No.
Is a reasonable officer prepared? Should a reasonable officer be prepared to expect a change in a crowd?
That'd be part of the situational awareness and planning process.
If one perceived threat or risk emerges while you're dealing with another, how is a reasonable officer trained to determine which risk or threat he should be dealing with?
The officer's trained to address what they perceive to be the highest risk.
If a reasonable officer has reason to believe that a person is passed out, can a reasonable officer be trained that if that person comes to, they may be more violent?
They could.
Has that happened to you in your law enforcement career?
It has.
And is that something a reasonable officer would take into consideration in assessing whether it be a use of force or a use of prone restraint?
They should take it into account.
Would that cause a reasonable officer to be more or less concerned?
Aware and more concerned.
I have no further questions.
Any recross?
I do. So you're not still contending that the prone restraint here was one that would not be likely to cause pain, are you?
It could cause pain.
Could cause pain, did cause pain, correct?
I don't know if it caused pain. I'm saying it could cause pain.
Did you look at the autopsy photos? Were those submitted to you?
No.
Right, so you didn't see the bruises on this man's shoulders? Didn't see that?
No.
You didn't see the bruises on his face?
No.
You couldn't use your context clues to determine that somebody trying to lift their body up with their face against the pavement, that would cause pain? It would cause pain, wouldn't it?
Lifting the face up off the pavement?
That's right.
Not
No,
necessarily.
using your face to lift your body up off the pavement. That would cause pain.
Objection? Overruled on that ground.
That could cause pain.
The only struggling that you saw Mr. Floyd doing after he was restrained was struggling to breathe. Isn't that right? Well, that
Overruled on that ground.
I don't know. If he was struggling or was he struggling to catch a breath, I can't tell.
in any event, struggling to breathe is not active resistance, is it?
To me, no. To the officer, maybe.
But officers are trained in terms of the dangers of positional asphyxia. Officers are trained that there can be a physical response to having oxygen deprived of you as a result of the pressure. Isn't that right?
There can be.
Overruled. You can answer.
They're trained about that.
Yes.
Correct? And it's much like the analogy that's used if somebody's holding your head underwater, there's a natural reaction to struggle, correct?
Yes.
And that's the danger, right, of the cycle of positional asphyxia, is that the officer might not recognize that what they're doing is causing the person to react. True?
It's quite possible.
And you don't contend that it was reasonable for the defendant to hold Mr. Floyd down on the pavement in this position to avoid him getting hit by a car, are you?
No.
No.
I said no.
All right. All right. Thank you, Your Honor. Nothing further.
Anything further? No, Your Honor. Thank you, sir. You may step down.
Thank you.
Members of the jury, our next witnesses are not available till tomorrow, and so we're going to recess for the day. The lawyers and I have some issues to deal with right now, and also at 8:45 tomorrow. But we still hope to start about 9:15 or 9:30 tomorrow. Hopefully, we'll be done with our issues by then. So, have a good night. Don't talk to anyone. Don't watch the news. Thank you. Council, we have some time here at the end of the day. We have some cleanup matters as far as exhibits, and some that were provisionally offered and some that were, I think everybody assumed were offered. Mr. Frank, anything you'd like to do to clean that up, or?
Sure, Your Honor. Can I stay here? Am I close enough to the microphone?
You're close enough to that microphone, and it is on, so.
Your Honor, we have a number of questions regarding exhibits, and I think we can deal with them on the record at this time. Your Honor, we understand that Exhibit 15, the record may reflect it had been conditionally offered through Donald Williams because Ms. Frazier was going to testify later. If it was not made clear that that was then being formally offered, sufficient foundation was certainly laid for that during Ms. Frazier's testimony, so we would ask that Exhibit 15 be formally offered at this time and received.
Any objection to that, Mr. Nelson?
Your Honor.
It is formally received.
And Your Honor, we had Exhibits 922 through 951, slides that were used during Dr. Tobin's testimony, and we just want to be clear that the record reflects we are agreeing that those should be considered only as demonstrative exhibits and should not then go back to the jury as substantive exhibits.
Agreed, Mr. Nelson?
Agreed.
It did appear that they were demonstrative at the time, even though it was not specifically stated, so we'll change the status of those to demonstrative only. It will not go back to the jury.
And Your Honor, during Dr. Smock's testimony, there was reference to a demonstrative about the signs of excited delirium. That may have been referenced as 921, may have been referenced as 941 when it was actually 921. 941 obviously falls within the exhibits we just talked about as demonstrative. So that we believe should be marked as 921. We understand that that's a demonstrative anyway and would not go back to the jury.
Is that correct?
I'm not doubting Mr. Frank.
So one more time, Mr. Frank, 941 should actually be 921?
I think it may have just been referenced during court as 941. We have it marked as 921, and it's a demonstrative anyway.
All right. So, Mr. Schaefer, how do you have it?
That's the 10 signs of excited delirium.
Correct.
Yeah, I had it in the record as 941.
All right, leave it as 941? Demonstrative only, or did you want?
So then there would be two 941s. So when
Correct.
it should be 921.
So the slide deck on excited delirium, which was marked and received as 941 for demonstrative purposes only, should be remarked as 921 for demonstrative purposes only.
Correct.
I believe that's correct, Your Honor.
All right, so ordered.
Then, Your Honor, during the testimony of Chief Arredondo, there was reference made to Exhibit 269, which was the map of the Minneapolis precincts. Our records show that that was offered and received, but maybe some question about that. So at this time, we are formally offering 269.
Any objection to that? That's the colored precinct map, is that correct?
Correct.
No objection.
269 is formally received. Can we return back to 9? I forgot what we finally marked it as. The excited delirium slide deck. 921. I think the record should reflect we had a chambers conference about redaction of that before it was given to the jury.
No, that's a different one, Your Honor.
Right.
Okay. I'll wait for you guys, and I'll speak when you speak to it. Because we did have a chambers discussion and a redaction.
That will be 1,053-ish, but we'll come back to that if we can.
Sure.
Okay. Your Honor, Exhibit 110, which is one of the Minneapolis Police Department Defense Policies Training Guide. We indicate it was offered and received during Lieutenant Mersel's testimony, but there may be some question about that. So just to clarify for the record, we are formally offering 110.
One moment, Your Honor.
And that was, again, your description?
It's the Defense and Control Response Training Guide.
No objection.
All right. 110 is formally received.
Your Honor, Exhibit 255, we indicate that it was offered and received during Sergeant Steiger's testimony, but again, there may be a question about whether that was actually done, and so we would just formally offer 255 at this time.
Mr. Nelson?
155.
255? And what's the description of that again, Mr. Frank?
It is a screenshot from King's body-worn camera at 8/19/35.
That's one I don't have a copy of. 255, I don't have a copy of that one, Counsel.
255?
And it was at what time?
8/19/35.
So 2019, 35.
Correct.
You have that it was offered and received, but the court doesn't, right?
Correct.
Yes, no objection.
All right, 255 is received if it was not before.
And Your Honor, Exhibit 122, which our records identify as the MPD Crisis Intervention Training PowerPoint, we believe was referenced, may not have been formally offered, but we would offer it this time.
Can I have a moment to chat?
Sure. And the number again, Mr. Frank?
Your Honor, upon further review, we would withdraw Exhibit 122.
All right, 122 is withdrawn.
Your Honor, then, just for clarification of the record, if it's necessary, Exhibits 624 and 628 were just only used to refresh recollection, not offered as exhibits.
Understood. Marked but not offered or received.
I believe that clears up the rest of the questions.
Those were just offered to refresh recollection. You said they were never offered formally.
Correct.
Mr. Schaefer, anything else that, any other loose ends?
Oh, I think we have it, but can I get the inclusive number of the demonstrative from Dr. Chauvin? Did you say it was 922 through 951?
922 through 951.
Okay. Are we ready to talk about the milestone camera and the player?
Yeah, that was the next thing on our list.
Mr. Nelson?
So, Your Honor, our request was that the milestone video that was introduced, I believe as exhibit 11, that the state introduced as exhibit number 11, which was the milestone video in its entirety, but it was cropped and excerpted, meaning it was not the entire 3 hours or whatever. It is the defense position that we don't have an objection to that being excerpted as far as the length of the time. However, it's our position that the actual evidence in the case would include the player for the milestone as opposed to a recorded version of it. The reason is, Your Honor, when that exhibit was demonstrated or published in court, it appeared to be very choppy. It appeared to be at a reduced period of time. I don't know if that was simply a computer problem or some technology problem. When I look at it on my computer, I see the same choppy thing, choppiness to it. The milestone player, as was testified to by Lieutenant Rubel, specifically allows the camera to zoom in, zoom out, be manipulated. You can see that in the video, the user of the video is actually doing that at times because the cameras can be moved. That's the actual exhibit, and it allows the jury to interpret that video accordingly. The submission that was conditionally accepted is not the actual exhibit. It's not the best evidence.
Mr. Frank?
Thank you, Your Honor. I'm not quite sure what best evidence rule is to do, but let me just say it this way.
I think he was using it as a phrase and not the rule.
Yeah, probably. I guess.
Say again?
Not sure anybody really knows what the best evidence rule means anymore, so I'll move on. Your Honor, we offered Exhibit 11 for a specific purpose, and that was for the 911 operator, Jenna Scurry. It was cropped because the Speedway sign occupies a big corner of that video. And so that's why it was offered as Exhibit 11. We offered, and the court received Exhibit 42 through Lieutenant Rugel. That was the milestone video of about 49 minutes long. That is the full video. It has the Speedway sign. It's from the time that Mr. Floyd is at the store to the fire truck leaves. That's the full video that we intend to offer. It plays we still believe that the slight catching of the video was just simply a computer issue at that time and getting it to load and play. Before we send the exhibits back to the jury, we'll of course make sure that it plays at its normal speed. But that's the actual video, and that's all we intend to offer. It plays, and that's all we intend to offer.
Is 11 a subpart of 42?
Correct. And I apologize, Your Honor, I was referring to the wrong exhibits. But yes, 11 is a condensed, excerpted, and cropped version of 42.
So we're just talking about whether the player should go back for 42.
With the same length of time, and that would be our position, yes.
How did Lieutenant Rugel play it when he was testifying?
Your Honor, we had an offer of proof with Lieutenant Rugel, where when it was originally played, the jury went out and I showed how it would actually worked with the player.
So, what's the state's position about sending the player back?
Your Honor, I think the jury should receive the video itself and not be given the player so that they can zoom in and zoom out. They should have the evidence that is the video and not the player. That's our position.
Mr. Nelson?
It's not the milestone video without the player. And so, again, it's within the province of the jury. They may not use that feature. I mean, it is the evidence.
It is the video. We laid a foundation for it through an expert who works in the field. It's the video itself.
All right. If you've tested it out on the computer that's going back to the jury and it plays smoothly, I'm going to deny the request to send the player with because the tools of the milestone video player were not used as part of testimony, and the evidence itself is the video. And so to allow the Zoom and other features were not really offered as part, and so, but if it's choppy, the player's going back. Pure and simple. Because they have to have a way to play what is, as the state says, the evidence, and that is the video. Can't be choppy, can't be a different speed. It's got to be real time, going ahead with the player or not. So let's make sure that happens, and if the state can make sure you represent back to the court that it is in working order. And I'll assume it is, but please verify that you've done the testing. Thank you. Anything else that we have to clean up? Mr. Slisher?
If I may, counsel indicated in the bench conference today that he has a motion that he wants to make. He wants to address that.
Oh, yes. We went immediately from the state resting into the defense case. I had assured Mr. Nelson off the record to maximize the jury's time that he could reserve his motion until we had a break when the jury was not present. Accordingly, any motions he makes as far as a judgment of acquittal are timely, and they're just being memorialized at this time. Mr. Nelson?
If we could take that up tomorrow morning, perhaps come a little bit before the other hearing.
Let's do 8:45. We should be able to do most of this. All right, we'll take that up tomorrow. Any other motions? I did want to memorialize, I think you said it was 1053 was the exhibit, the excited delirium slide deck. Is that correct?
Correct. I believe it's, let me just double check here.
In any case, we had a chambers conference at the state's request to talk about redactions, and I did order redacted one picture out of that because it was not relevant, and given the very limited purpose for which it was offered, deleted the picture that showed someone being restrained in the prone position with a knee on the neck. It was not part of the excited delirium presentation. It was just coincidental with some of the facts we might have here. So that photo was redacted, and also there was a list of references of the last slide. That was deleted because we don't want to have the jury look at that and then decide to do some internet research. Not that they would have the tools back there, but in deliberation, but nevertheless. So those are the redactions that I was aware of. Is that correct?
And I completed those redactions over the lunch hour. I provided a copy to the state.
All right, and that will receive that redacted version as Exhibit 1053. I think that was all the bench sidebars that that were substantive. Everything else seemed to be non-substantive scheduling. Anything else that we have to make a record of before tomorrow?
Your Honor, we have been just taking notes of bench conferences throughout the course of the trial.
Sure.
And in terms of some of the bench conferences, at least from our position, and not expecting the state to respond to these immediately, but in terms, I just want to memorialize some of the conferences that we've had either in chambers or at sidebar. Your Honor, it is based upon our recollection that on March 30th of 2021, in a morning chambers meeting, in terms of the adolescent witnesses who testified that the court directed the state to lead the younger witnesses, gave them permission to lead the witnesses. That was all within the context of the discussion about whether they would be videoed and audioed and things of that nature. With respect to Mr. Williams's testimony, there was a sidebar where the defense objected. I think you sustained the objection as to Mr. Williams being a security expert. Just wanted to note that that was the substance of that sidebar. At sidebar, a second sidebar, there was a defense objection as a repetitious questions about Mr. Williams feeling that Mr. Floyd was in danger. The defense objected to that.
May I make a suggestion, Your Honor? If we could maybe shorten this up, perhaps email us summaries of bench conferences, we could take a look and then have something that we agree to that we're going to present to you tomorrow.
I think that's reasonable. We'll get that sent out tonight.
All right.
Just one last thing, Your Honor. In terms of just, as the court is aware, there's been ongoing disclosures that have been going on throughout the course of this case. And I think we could probably have a chambers conference regarding a couple of things if the court would be so inclined. But as based on my records, at the point that this trial started, we had received 29 disclosures totaling 45,118 bait stamps items. As of yesterday's date, we were up to 41 disclosures totaling 50,272 disclosures. There have been some discussions, and I know that there have been more disclosures that have come in since. Some of these disclosures involve potential impeachment materials of expert witnesses and things of that nature, and they are quite voluminous. And so if we could have a discussion about what, if any, of these materials the state would intend to impeach with, that would potentially be helpful. I think we're up to, as of yesterday, we were at 50,272. So it would be very helpful to help have a meaningful opportunity, for me to have a meaningful opportunity to review those between now and tomorrow, when I expect a couple of experts to testify.
Are these related to your experts?
I believe a significant portion of it is.
All right. Since the disclosure is fairly late, I'm not saying untimely. I'm saying, but it is late in the game. I would ask that the state meet with Mr. Nelson and kind of indicate what it is you're planning on impeaching with.
Your Honor, we continue to be of the position that those are matters we have actually no duty to disclose, other than the court's order in this case that we do them. Of course, that order was made at a time recently, and we have been disclosing those things that we had, and that as we continue to get, of course, as we prepare for these witnesses. They may never be used, but they're potential for impeachment, and the court ordered us to disclose them, so we're doing that.
Okay.
Now, to further ask us to tell counsel what we're going to use to impeach, it's a little difficult to do before you hear the testimony.
Well, I could continue the trial, so give them time to prepare.
I don't see a need to do that, Your Honor.
I think this is my point. I'm not saying the state is acting in bad faith, not at all. These things are moving targets. But when we are actually in trial on the eve of Mr. Nelson calling these witnesses, and I would not restrict you to what you could impeach with. I'm just saying what you know you will use to impeach these witnesses, if you could at least highlight those, reserving the right to put other things in. Because I'm sure there's stuff that right now you know what you're going to use to impeach. Other things maybe, maybe not. The maybe, maybe nots, I'm fine with you just waiting. But if you know there are things you're going to impeach with, I think it is appropriate, given the fact that these are being disclosed late in the game, again, not making any accusation of impropriety, just they are late in the game. I don't want to have to give Mr. Nelson a continuance and have the jury sit around to give him an appropriate amount of time to prepare. What I'm saying is it gets us to putting these witnesses in front of the jury quicker if we just work together on highlighting things. So I am ordering the state to at least what they know for sure they're going to impeach with.
Understood, Your Honor. We'll do what we can.
All right. I appreciate that. Okay. Anything else for the record? I do need to talk to you in chambers about an issue that relates to security. Security, everybody. I need counsel. Just counsel. All right. Thank you. We are adjourned for the day then. Let's get back at 8:40.